Compliance Presentation, Moral Rights to Healthcare by Deborah P. Stevens, HCA 322, Healthcare Ethics and Medical Law. Instructor Ken Pfeiffer. Hello, Instructor Pfeiffer and fellow classmates. I will be discussing several elements in regards to the moral rights to healthcare. The three elements in which I will be discussing are the Code of Ethics, patient rights, patient safety, and the Stark Law. The healthcare industry is one of the most regulated industries in the United States. As per dictionary.com, the word moral means of relating to or concerned with the principles or rules of rights, conduct, or the distinction between right and wrong. Ethical, and the word rights means civil rights. For many years, moral rights to healthcare has been an issue and debate. If it is not the cost of healthcare services, providers, insurance companies, etc., it has been who is qualified, whether healthcare services could be given when and how in emergency rooms, what kind of insurance one has, and so on. For many years, the problem has existed whether individuals can afford or is able to pay for healthcare services and medicine or not. Since we are all humans and our bodies are doomed to get some kind of sickness, illness, and or disease at one time, which causes us to stop our day-to-day businesses and activities until we get some kind of remedy for the cause. In these cases, we will all need to visit a healthcare facility at one time or another in our lifetimes. This is why it is everyone's moral rights to health care, whether we can afford it or not. Having access to health care should be an ethical, basic human right. If an individual is sick and they're requesting services and they should go to a healthcare facility of their choice or emergency room, it would be the healthcare's ethical choice for industry. There are several areas of operation that are affected. Healthcare ethical dilemmas develop between providers and patients when there may be conflict of personal ethical standards. The Code of Ethics provides a standard for operation so that all participants understand that if they do not adhere to this code, there may be negative consequences. The Code of Ethics consists of two kinds of standards, principles and rules of conduct. The principles are broad standards of an inspirational nature, and as such express ideas of exemplary professional conduct. The rules of conduct are specified standards that prescribe the minimum level of conduct expected of each HCCP. Compliance with the code is a function both of the individual professional and the professional community. The Health Insurance Portability and Accountability Act, known as HIPAA, the statute established a duty for healthcare providers to notify patients of their rights to confidentiality, including the right to receive and accounting of the disclosures made under provisions of the Act, the rights to access and, in some cases, amend their PHI. HIPAA provides civil and criminal penalties for violations by those to whom the law applies. HIPAA initially applied only to cover entities, which include healthcare providers, health plans, and health clearinghouses. However, the Health Information Technology for Economic and Clinical Act of 2009 extended HIPAA's requirements to business associates. That is, entities likely to come into contact with or have the opportunity to access PHI that perform a business function for the covered entity. Many healthcare organizations are held to high standards of conduct on behalf of the patient. The patient has the right to the best health care that they can get and privacy during the time they need their health care. Any procedures that the patient needs are carefully explained and communicated by the healthcare provider. In doing so, informed consent is required by the patient for the health procedure that is accomplished through the collaboration of the provider and the patient working together to meet the care needs of the patient. Giving the patient an autonomy over what happens to their body produces the better results for everyone. Rights and standards. A patient bill of rights attempts to lay out a series of rights and standards that all patients are entitled to when receiving medical care, including the right to privacy. There has to be a balance between patients' rights and other values and priorities. In healthcare, no one should dispute the rights of patients are important. Health has always been given a low priority status in the nation's political and social agenda. With increasing privatization of the healthcare services in the country, the state is slowly abdicating its responsibility to provide healthcare to people. Medical professions contributes to the healthcare to the extent of 25 to 30%. A brief history of Patient Bill of Rights. Starting in the 1990s, a number of issues signaled a healthcare crisis, including financial strain, an apparent and equal distribution of healthcare, increased costs, and mounting public distrust of healthcare insurance, and the healthcare corporations that seem to place profits above patients. In 1993, there have been several attempts made by former President Bill and Hillary Clinton to secure rights for patients in the United States. In 2001, Congress considered the Bipartisan Patient Protection Act, informally known as the McCain-Edwards-Kennedy Patients Bill of Rights. The bipartisan bill was a list of guarantees for Americans already covered by some form of health insurance or group health plan. These rights promise to improve managed care through formal utilization, review processes, required the health and coverage to be expanded for plan participants to ensure adequate access to care, protected a plan participants' access to information, as well as the privacy and confidentiality of the information, to minimize possible conflicts of interest, as well as inappropriate influences on physicians. Then the United States Department of Health and Human Services established a Patients' Bill of Rights, which affected Medicare managed care plans in 1998, Medicare hospitals in 1999, and Medicaid patients in 1999. In the 1990s, the Joint Commission's Patient Bill of Rights, also called the Patient's Rights, included technical protections for human subjects involved in clinical research. The Commission's Patient Rights emphasize the patient's duty to cooperate with healthcare providers to jointly achieve the goals of treatment. 13 of the most common themes found in patient bills of rights is considerate and respectful care. Number 2, obtain current and understandable information such as diagnosis, treatment, and medicines. 3, medically indicated care, including transfer to another facility. Number 4, refuse recommended treatment. Number 5, have or obtain an advance directive. Number 6, privacy. Number 7, confidentiality of communications and records. Number 8, review patient records. Number 9, be informed of conflicts of interest. Number 10, refuse participation in research with no diminishment of care. Number 11, reasonable continuity of care. Number 12, be informed of care costs and policies for patients, responsibilities, and resolution of conflicts. And 13, be informed of patient rights. The Stark Law. Before the Stark Law became into effect, physician healthcare facilities and their counterparts were submitting false claims that was not deserving, ordering tests, scans, and other medical needs of the patients, needlessly falsifying claims, which was made, in fact, not actually provided to an eligible beneficiary. The intent of the Patient Referrals Act, or the Physician Self-Referral Act, better known as the Stark Law, is a federal statute whose purpose is to limit conflicts of interest in situations where physicians have financial relationships, causing them to steer Medicare patients and other patients to facilities and certain providers who potentially overutilize services based on their financial relationships, causing them to submit claims provided under such referrals. The Ethnic and Patient Referrals Act, or Stark Law, came about to govern referrals for Medicare and Medicaid reimbursed services in which the physician or close family member has a financial conflict of interest. Physicians and other healthcare providers who engage in these kinds of actions it also governs the abuse of anyone knowingly, willfully offer, pay, solicit, and or receive remuneration or induce or reward referrals of items of service reimbursable by the federal health care program. Physicians and other healthcare providers who engaged in these kinds of actions committed the crime statute offense called the anti-kickback statute. When one committed the anti-kickback statute, referrals did not necessarily have to come from physicians. It could have come from anybody for any service. And that brings us to the QTAM action. During the Civil War era, Congress passed the False Claims Law, FCA, in response to the growing concern of government contractors submitting fraudulent account statements and shipping defective orders to the government. To protect the United States government, the USA provides and diminishes fraudulent behavior by government-funded defendants by imposing restitutionary penalties. Known as the QTAM action, the FCA allows private persons referred to as relators to bring claims for penalty of which the federal government is entitled to receive a share. QTAM actions allow private citizens, whistleblowers, suing each individually or through the state to bring legal actions against entities and individuals who should break a federal law.